Hello everyone, and welcome to Uncivil Law. I'm joined for today's video by guest Tactical Bra. And for today's video, we're going to be discussing the case of United States of America versus Roberto Arturo Perez. Mr. Perez was a bank robber, and he was sentenced for being a bank robber. And during his sentencing, he was given a sentence enhancement for making death threats while he was engaged in his bank robbery. However, the Court of Appeals analyzes the notes and concludes he's actually a very polite bank robber, and so concludes the sentencing by the district court was an abuse of discretion and sends it back to the district court for resentencing in light of his politeness. So we're going to read the tale of the polite bank robber, and let's get started with this. If this were an Encyclopedia Brown mystery, it might be called The Case of the Polite Bank Robber. Without any weapons, defendant appellant Roberto Arturo Perez calmly walked into two different banks. He handed each teller a banknote with instructions using words like please and thank you, made no reference to any type of weapon, bargained pleasantly with one teller for $5,000, and allowed another teller to leave the post and report the robbery while it was ongoing. I guess my mother was correct that please and thank you will definitely get you a long way, so that's good to know. All bank robbery charges are necessarily involving implicit or explicit threats of some type, since they always must occur by force or violence or intimidation to qualify as bank robberies under the statutes. But the guidelines punish harshly defendants who use implicit or explicit threats of death to accomplish bank robberies than those who employ lesser threats. Here we decide that when the district court clearly erred in concluding Perez's conduct and choice of language would have instilled a reasonable person a fear of death, justifying application of the guidelines threat of death enhancement. In other words, we must evaluate whether Perez's bank robberies were of the less bad variety by guideline standards. After careful consideration and with the benefit of oral argument, we hold they were. We will therefore vacate Perez's sentence and remand for resentencing. So I suppose the object lesson here is, while crime doesn't pay, being polite sometimes does.
Yeah, I guess being polite means it was less bad.
Yeah.
Which,
Le-
yeah,
yeah.
okay,
So
okay.
we can learn that Canadians everywhere can rob banks with lesser implications. So there's good news, I suppose, there. Does Canadian law also have exceptions for robbing banks politely, or how's that work in Canada? I want to know. Since everyone's polite already, what does it take for a Canadian to get mercy for politeness? That's a good question.
I think I'm trying to think. I feel like there might have been a case at one point in which someone did not brandish a weapon. They just demanded. They said, like, this is a bank robbery, like, put the money in the bag or whatever. But they didn't, obviously brandish a weapon. What does that count as if the person wasn't armed? They're still doing a robbery. And I mean, for the teller, what the company wants and what insurance wants and what everybody wants is for the teller to just comply because they shouldn't risk their life. And it's better to be wrong about him having a weapon than to be wrong about him not having a weapon, right? Like, I don't know if you've ever worked retail during the Christmas season, but there'll be the staff meeting being like, we're going to be handling a lot of money. And by the way, if anybody tries to rob us, here's everything that you can do to not get killed. But now I'm wondering, do you have to explicitly like brandish a weapon? Do you have to be really rude when you commit a robbery?
Well, let's read on and
I don't
find
know.
out. First, in March of 2017, Perez entered a Chase bank. He was wearing a baseball hat, dark sunglasses, a t-shirt, and pants. Perez, who was not carrying a weapon, gave the teller a note that read, "Put $5,000 in an envelope, put the note inside as well, stay calm, do this and no one will get hurt, press the alarm after I walk out, I have kids to feed, thanks." Very polite. In response to receiving this note, the teller explained to Perez that the teller would need to type a code into the computer to dispense cash. Perez directed the teller to do so. After the teller entered the code, the teller placed $1,000 in cash on the top of the counter. Perez took the money and counted it. Then, pointing to his written note seeking $5,000, Perez asked the teller if that was the most cash the teller could dispense. In response, the teller gave Perez another $1,000 and placed it on the counter. This process occurred 3 more times for a total of approximately $5,000. Perez took that money from the teller's counter and exited the bank. This is the strangest negotiation I've ever seen in my life. He gives a note saying, give me $5,000. The teller gives him $1,000. He says, can you give me any more? Gives him another $1,000. Says, can you give me any more? Gives him another $1,000. Says, can you give me any more? Gives him another $1,000. Says, can you give me any more? Gives him another $1,000. This is the most, this is like some weird crossover between Pawn Stars and a bank robbery. It is very, very weird.
It sounds like a delaying tactic, but all of the instructions that I have been given when I worked retail was to don't do that. I was given instructions. Don't look them in the face. You look at them out of the corner of your eye. You move deliberately. You say what you're reaching for before you reach for it so that they don't get spooked and then attack. And they're like, look, you will not be held responsible if somebody robs the place. Please don't die. So all of the training that I have been given, now this might have changed and this might be different at banks, but everything that I've been told is don't frustrate the robber because it's not worth it.
Yeah. Fair enough. 6 days later, in March of 2017, Perez entered a Wells Fargo bank. This time, besides his baseball hat, dark sunglasses, and shirt, he wears shorts rather than pants. Shorts. Very intimidating. Perez again did not carry a weapon. When Perez approached the bank teller this time, he gave the teller a note that read, act normal and stay calm. Take $20,000 and put it in an envelope and no one gets hurt. Please sound the alarm in 10 minutes. I got kids to feed. Thanks. Very polite again. In response, the bank teller signaled the bank alarm system and then simply left the bank counter, entered a bank room to inform a supervisor and others of the robbery in progress. They, of course, dialed 911 to contact law enforcement. Remarkably, after several minutes, the bank teller returned to the counter where Perez, visibly agitated and aggressive, was waiting. Perez demanded the bank teller hurry up. Nevertheless, the teller stalled Perez until law enforcement arrived and took him into custody. With that very polite factual predicate out of the way, let's get into the law that applies in this situation. Perez's pre-sentencing investigation report assigned Perez a combined adjusted offense level of 23. As relevant here, that included a 2-level enhancement for making threats of death. Based on a total offense level of 23 and a criminal history category of 1, which means no prior offenses, Perez's guideline range was 46 to 57 months of imprisonment. It's like 5 years, right? Yeah, it's a little less than 5 years. So that's a little bit, because 60 months would be 5 years. So you're talking about like 4 to 5 years of penalty for this bank robbery. So, not so bad, I guess, all things considered. Perez filed an objection to the 2-level threat of death enhancement. He then renewed that objection at sentencing. In summary, Perez contended, as he does on appeal, that the threat of death enhancement applies only when some additional conduct or language aggravates a mere threat of harm, evident in every robbery, to a threat of death. And because Perez did not engage in such conduct, the enhancement does not apply. It makes logical sense that it has to mean something beyond the mere underlying crime, because it's an additional factor. So you're looking for something more as part of the sentencing enhancement. And here when they're talking about different offense levels, we're in federal court, so this is referring to sentencing guidelines. They have different offense levels for different levels of prior offenses, and they have different offense levels for how severe this particular offense is. So you have a nice little grid based on the seriousness of this offense and seriousness of prior offenses that gives you a recommended sentence. And that is a recommendation. The courts can go up or down from there, but they have to provide reasons when they do. But it gives a starting point to, at least in principle, help to ensure everyone is given equal justice, because everyone's given the same penalty absent some sort of normal circumstances. At least that's the idea. The court lamented that the parties failed to present any factual evidence about Perez's offenses, but instead relied on the investigative report's undisputed facts, which are recited above. Looking at the fact, the district court characterized Perez as having a sort of conversation or back and forth with the teller in the first robbery. As to the second, the district court recognized that the note had a sense of overall threatening, and yet it had a blandness to it, a plea to help for his kids. The district court opined there was certainly an element of fear in the matter that would put someone in concern about harm, regardless of the absent weapons or threatening nonverbal cues. On this basis, the district court concluded a reasonable person could have been in sufficient fear to warrant application of the threat of death enhancement as recommended in the investigative report. so it overruled defendant's objection. Nevertheless, the court sentenced Perez to 46 months imprisonment, the low end of the guideline range, because it determined Perez's threats were less severe than others that qualified for the enhancement. With the findings of the trial court out of the way, now we get into what the appeal court is going to analyze. According to Perez, the district court imposed the threat of death enhancement based upon a lower finding than necessary by the rule. Specifically, Perez contended that the district court only found that Perez's threats would have placed a reasonable fear of danger or harm, which is evident in every bank robbery, but which, without more, cannot suffice to sustain a threat of death enhancement. Secondly, Perez argues that even if the district court applied the correct legal standard, it erred by finding the facts of this case warranted the imposition of the threat of death enhancement. And then, somewhat remarkably, the government agrees. So here, the U.S. attorney is also agreeing with the defendant. The district court misapplied the sentencing guidelines. So the government is agreeing with the appeal that they messed up on the court below. So you don't see that every day, particularly in a criminal court case where the government is saying, yeah, the district court actually screwed this up. And the U.S. attorney is saying, yeah, you gave him more time than is warranted under these guidelines. So not something you see every day, but it's what happened here. Pretty remarkable. Nevertheless, we have an independent duty to decide the matter before us according to law, and parties' agreement about or stipulation to a particular view of the fact of laws does not absolve us. We are not required to accept a concession from the government when the law and record do not justify it. For this reason, a judge of this court appointed an amicus lawyer to defend the district court's judgment. So here they're saying the issues that apply are legal issues, and the issue applied is a legal decision whether the court below erred in a legal finding. And so simply because the U.S. attorney says that this is a law that should apply doesn't mean the U.S. attorney is right, even any more than if they were disagreeing. So here they're saying, look, just because both parties say this is a law doesn't mean it is a law, and we're being asked to decide a legal decision. So what we're going to do to solve this problem is we're going to ask someone to defend the court below. We're going to hire a lawyer ourselves to defend the court below. So we're in a very weird position where the defendant is appealing, the government isn't objecting, and the court is going to appoint a lawyer of their own to defend the district court below. So really interesting factual predicate of how we are, but this is where we are.
Do you think that's a precedent issue that they want to be able to elucidate the arguments enough so that they can make a ruling that can be applied to other cases?
I'm not sure 100% exactly what the motivation here, but by the thing is, it's just like, the district court rendered a decision, and we're going to review that decision. Someone here should be arguing for the district court, and the government doesn't want to do it. It's not that they're dropping the case, so they're not saying, we're refusing to prosecute or something like that. In which case, you would imagine that they just let the case be dropped. They're saying, no, we agree that the case should be prosecuted. We just think that they messed up the application of the law. So it's not that we're giving up. We just have no quarrel with this particular issue. And so in that situation, it's like we want to prosecute but not defend this part of it. So someone should be arguing on behalf of the court. So I don't know if it's for precedential reasons, just so much it is to make sure that they're making the correct legal decision by having someone arguing the other side. So it's meant to elucidate the legal argument so that they can make a better legal decision. So works for me. A defendant is guilty of bank robbery or attempted bank robbery if he attempts to take money from a bank by force and violence or intimidation. Delineating between bad robberies and worse robberies, the sentencing guidelines set forth sentencing enhancement that account for how the defendant undertook the robbery at issue. As relevant here, the section imposes a 2-level enhancement when defendant makes a threat of death during the robbery. It applies when the defendant's conduct instills in a reasonable person who is the victim of an offense a fear of death. Because the enhancement looks to the reaction of a reasonable person, we apply an objective test to determine whether the defendant's conduct qualifies for an enhancement. Whether the defendant intended to threaten death is not determinative. Similarly, the actual victim's subjective fear is not dispositive, though it may be indicative. So that presents a very good delineation between an objective test and a subjective test. So if we were looking at this subjectively, we could look at subjectively 2 ways. We could look at subjectively from the point of view of the bank robber, or subjectively from the point of view of the bank teller. So if we were looking at subjectively from the point of view of the bank robber, we'd be asking, what did he subjectively intend? If we're looking at it from the point of view subjectively of the bank teller, we'd be asking, what subjectively did they perceive? But we're doing neither of those things. We're asking an objective question. So regardless of how this particular bank teller responded, how would a reasonable person respond? So we're trying to make this objective and asking the reasonable man test. How would a reasonable man in this situation respond? Fair enough. Perez's case does not involve materially the same facts as any of the other cases in our case law. Unlike prior cases in Murphy, Janinet, Carball, and Wooten, Perez's did not specifically state that he had a gun, nor did Perez imply that he had any weapon as occurred in the cases of Razowick and Emmett. On the other hand, Perez did expressly threaten tellers with harm. So while these other cases might set forth helpful road marks, we must still undertake the fact-intensive inquiry that considers the totality of the circumstances of the threat. We begin with analyzing the first robbery. Perez's demand note told the teller to put $5,000 in an envelope and no one will get hurt. That undeniably constitutes a threat of harm, but nothing else about Perez's robbery generated additional levels of fear associated with a threat of death. Perez did not wear a disguise, and the clothes he did wear did not independently suggest that he could have a weapon hidden in them, nor did the government present any evidence that Perez made threatening gestures, non-verbally indicated he carried a weapon, or acted menacingly. And a statement that he had kids to feed often likely softened the impact of the man, as it suggested that he was not devoid of empathy. Plus, nothing supports the notion that Perez aggressively demanded the money. In fact, the district court described the interaction as a sort of conversation. And although the teller easily could have given $5,000 the first time he asked for it, the teller nonetheless felt comfortable enough not to comply with the demand 4 separate times. This is not the conduct of someone in fear of death. The story is much the same for the second robbery. Again, we have no doubt that Perez's note constituted a threat of harm, but it was the case with Perez's earlier robbery. Nothing about the second robbery threatened death. Perez again wore no disguise and was obviously not carrying a weapon. In fact, he was wearing shorts this time, leaving even less room for stowing a weapon. And in the demand note, Perez again made reference to the need to feed his kids. This time, the teller felt safe enough to altogether leave the bank counter for several minutes and report the robbery to a supervisor who called 911. Then, even more surprisingly, the teller returned to the counter. Though Perez was visibly agitated upon return, the teller could not have found Perez's conduct was that imposing. After all, the teller opted not to comply with Perez's demand, but rather stalled until law enforcement arrived.
That's a gutsy move.
It is a gutsy move, and I do have to share the district court's conclusion that, leaving the room and then coming back does kind of suggest that you didn't feel like a threat of death, because if you felt like you were under a threat of death, who would do that? So, it is indicative that they weren't feeling death, and I agree with you. It's a very gutsy move because, you have no idea what could actually happen. So both bank tellers were not following your recommended list of things to do, like give them the money. They went with a different route.
Yeah, if my husband was the bank teller and he did that, I'd probably yell at him. Be like, I don't care if you were 95% sure that the person wasn't going to hurt you. That's still a 5% chance that you could get hurt, and that's too high in my books.
Because you actually love him, right?
Because I actually love him.
Aw, be still my beating heart.
I know. Plus, he does the dishes. Like, if he gets hurt, I would have to do the dishes.
Okay.
Both things can be true at the same time.
I understand. Because of love and because of dishes. These are even in my eyes. Both are good reasons.
Yes.
In short, whether the district court's application of the threat of death enhancement here arose from a clearly erroneous fact-finding or legal error in applying the law to the facts, our review of the totality of circumstances leaves us with a definite and firm conviction the district court reversibly erred. So that is the end of the case of United States of America versus Roberto Arturo Perez. In this case, we learn that mother's advice to always be polite pays off even when you're a bank robber. In this case, he was given an undue sentencing enhancement for making a threat of death, which, based on notes and actions of the people involved, did not exist. So the Court of Appeals found the court below committed a clear error by applying a sentencing enhancement that was not warranted by the facts. So this will be sent down. He'll get 2 groups later, and he'll be out even in shorter time. So I guess politeness does really pay in the end, and that is the end of this case.